This module is on safe abortion as a woman's human right. The content was written by Dr. Suchitra Dalvi, a coordinator at Asia Safe Abortion Partnership. By the end of this module, you should be able to understand the consequences of unsafe abortion on women's health, analyze women's rights to health as a human right, and recognize criminalization of abortion as a violation of many human rights of women. Unsafe abortion leads to 13% of deaths among young women and girls each year worldwide. Thus, somewhere in the world, a woman dies every 8 minutes because of an unsafe abortion. This is an average, and in some parts of India, as many as 50% of all maternal deaths are due to unsafe abortions. A study done by IPAS in 2007 in Jharkhand found that 20% of the reported abortions were carried out at home through unsafe methods, of which 51% of women had post-abortion complications. Each year, globally, 21.6 million women and girls experience an unsafe abortion while seeking to terminate an unwanted pregnancy. These are enormous numbers and a serious public health concern, as well as a gender and human rights issue. An unwanted pregnancy may result from contraceptive failure or failure to use contraception correctly or at all. Often, women do not want more children, but appropriate contraceptive methods are either unknown or unavailable to them. Moreover, all contraceptive methods have a failure rate, and therefore access to safe abortion is always needed, even in societies with 100% contraceptive prevalence rate. Country laws vary across the world with regard to the extent to which the access to safe abortion is allowed. Many countries in Asia, including India, have inherited their laws from the colonial rulers. The Indian Penal Code is almost identical to the earlier British Penal Code. The British law in their own country has now undergone many amendments, but the Indian Penal Code Section 312 still criminalizes abortion, specifying punishments for the provider as well as the woman. The Medical Termination of Pregnancy Act from 1971 is an act of Parliament which allows a termination of a pregnancy to be carried out under certain conditions. The termination must be performed by a person who's qualified and in an approved location. The law is liberal in its intent and allows a pregnancy termination under a wide range of conditions. A pregnancy may be terminated by a registered medical practitioner where the length of the pregnancy does not exceed 12 weeks, or B, where the length of the pregnancy exceeds 12 weeks but does not exceed 20 weeks. If the pregnancy is more than 12 weeks, 2 registered medical practitioners must be of the opinion that the continuation of the pregnancy would involve a risk to the life of the pregnant woman or of grave injury to her physical or mental health. Or there is a substantial risk that if the child were born, it would suffer from such physical or mental abnormalities to be seriously handicapped. The Medical Termination of Pregnancy Act also states that when any pregnancy is alleged to have been conceived by rape, the anguish caused by such a pregnancy shall be presumed to constitute a grave injury to the mental health of the pregnant woman. The Act also states that if any pregnancy occurs as the result of a failure of any device or method used by a married woman or her husband for the purpose of limiting the number of children, the anguish caused by such an unplanned pregnancy may also be presumed to constitute a grave injury to the mental health of the pregnant woman. In determining whether the continuation of a pregnancy would involve such risk of injury to the health of a woman, as is mentioned in this subsection, account may be taken of the pregnant woman's actual or reasonable foreseeable environment. Although the Act does not recognize safe abortion as a woman's right, and no access to abortion on demand exists, there is no doubt that this law has had a significant impact on the reduction of deaths caused by septic and unsafe abortions. However, the tragic reality is the vast majority of women and even some community health workers in India are still unaware of the law. A study from the Population Council India states that in a community-based study in Rajasthan, only 1 in 6 men and women were aware that abortion was even legal. Even more alarmingly was that nearly 4 in 5 men and more than 1 in 2 women believed it was illegal, and formal services are less likely to be sought when women perceive abortion to be illegal. Apart from awareness, there is also problems with implementation in terms of providers and equipment and sensitive services in the public sector and the costs and quality in the private sector. The situation has been made worse in the last decade with the vigorous implementation of the PCNDTA Act, whose posters and slogans have made it seem as though all abortions are illegal, rather than conveying that sex determination as a practice is illegal. Second trimester abortions are more likely to be denied due to fear of sex determination, and such women are forced to seek informal and unsafe abortion services. Unsafe abortions are still a reality in India and contribute to at least 13% of pregnancy-related deaths in women and girls. The vast majority of abortion seekers continue to be married women seeking to limit their family size. Unsafe abortions can have many health consequences, including death. The Center for Reproductive Rights states that forcing a woman to undergo life-threatening, unsafe abortions threatens her right to life. They also emphasize that denying women access to abortion is a form of gender discrimination. The health consequences of illegal and unsafe abortion are important to distinguish. It is important to distinguish between illegal and unsafe abortions. In countries with restrictive laws, doctors may provide services which are illegal but safe. Common complications of unsafe abortions may range from infections and infertility to serious infections and injuries that may lead to the need for removing the uterus and even parts of the intestine. Severe blood loss needing transfusions and death due to hemorrhaging may also happen. Internal injuries and infections may also lead to lifelong chronic health problems. Providing access to safe, accessible termination services helps to reduce the chances of all of these consequences. Access to safe abortion therefore reduces the mortality rate of women and girls who lose their lives as a result of infections or complications caused by unsafe termination services. Unsafe abortions and maternal mortality are something the UN has often spoken about. The UN Human Rights Committee has discussed illegal and unsafe abortion as a violation of Article 6 of the International Covenant on Civil and Political Rights, which is the right to life, and has made the link between illegal and unsafe abortions and high rates of maternal mortality as a violation of this right. The Human Rights Committee has also requested that states parties provide information on the effects of restrictive abortion laws on maternal mortality. The committee has also urged state parties to revise their national laws to help women prevent unwanted pregnancies and to prevent women from having to resort to clandestine abortions, which put their lives at risk. Analyzing women's rights as a human right has also been discussed by the author Rebecca Cook, and she states in her article on human rights and abortion laws that human rights are invoked both to support and to oppose choices to terminate pregnancies. Within the preamble of the United Nations Charter adopted in 1945, the Charter reaffirms faith in the fundamental human rights and dignity, worth, and equality of the human person. It also emphasizes equality between the rights of men and women and of nations large and small. The Charter recognizes that one purpose of the United Nations is to achieve international cooperation in promoting and encouraging respect for human rights and for fundamental freedoms for all without distinction as to race, sex, language, or religion. In 1999, the Committee on the Convention for the Elimination of All Forms of Discrimination Against Women elaborated the link between human rights, freedom from discrimination for women, and women in health in general. In General Recommendation 24 on Article 12 of the Convention, which is the right to health, within the section headed Recommendations for Government Action, the General Recommendation highlighted the need for state parties to implement a comprehensive national strategy to promote women's health throughout their lifespan. This will include interventions aimed at both the prevention and treatment of diseases and conditions affecting women, as well as responding to violence against women. The General Recommendation wanted states to ensure universal access for all women to a full range of high-quality and affordable healthcare, including sexual and reproductive health services. The recommendation also required states parties to allocate adequate budgets, human and administrative resources to ensure that women's health receives a share of the overall health budget comparable with that of men's health. This took into account the different health needs of men and women. The recommendation also stated that states should prioritize the prevention of unwanted pregnancy through family planning and sex education, and reduce the maternal mortality rates through safe motherhood services and prenatal assistance. It also wanted legislation criminalizing abortion to be amended in order to withdraw any punitive measures imposed on women who undergo abortions. The General Recommendation also required all health services to be consistent with the human rights of women, including the right to bodily autonomy, privacy, confidentiality, informed consent, and choice. The obligation to reduce maternal mortality rates through safe motherhood services clearly applies to the mortality of women caused by accessing unsafe abortion services. Further, the obligation to provide interventions aimed at both the prevention and treatment of diseases and conditions affecting women, if read to include infections and conditions in addition to diseases, also applies to preventing the infections and conditions caused by accessing unsafe abortion when safe abortion is unavailable or culturally, geographically, or financially inaccessible. The United Nations' International Conference on Population and Development said that reproductive rights must embrace all human rights that are already recognized in both national and international laws and in international human rights documents. The Conference on Population and Development clearly stated that reproductive rights rest on the recognition of the basic rights of all men and women to decide freely and responsibly the number, spacing, and timing of their children, and to have the information and means to do so. The right to attain the highest standard of sexual and reproductive health. It also includes the right to make decisions concerning reproductive freedom. These decisions should all be free from discrimination, coercion, and violence. Women's rights must also mean their human rights to health. Women's rights are human rights is a term used in the women's rights movement and is the name of a speech given by then American First Lady Hillary Clinton on the 5th of September in 1995 at the United Nations' Fourth World Conference on Women in Beijing. In her speech, Clinton targeted governments and organizations as well as individual women, as she opined that the issues facing women and girls are often either ignored or silenced, and thus go unresolved as they are not treated as priority issues like other human rights. Issues brought up in her speech include dowry deaths and China's one-child policy. The speech is considered to be influential in the women's rights movement, and in 2013, Clinton, then as Secretary of State for the USA, led a review of how women's rights have changed since her 1995 speech. 45 years after the Universal Declaration of Human Rights was adopted, and 18 years after the Beijing Conference and subsequent Beijing Platform for Action. This marked International Women's Year, and 12 years after CEDAW entered into force, the 1993 UN World Conference on Human Rights in Vienna confirmed that women's rights were human rights. That this statement was even necessary is disappointing, since women's status as human beings entitled to rights should have never been in doubt. Sexual and reproductive rights are also human rights. The International Planned Parenthood Federation, otherwise known as the IPPF, is the largest global federation working on sexual and reproductive health delivery, as well as advocacy. It has developed a charter on the sexual and reproductive rights of women as a response to the challenge of interpreting human rights language and applying it to sexual and reproductive health care issues. The classification of specific issues under certain rights represents the organization's judgment of where each issue should best appear. It should be noted that, by their membership in international human rights conventions, states recognize legal duties that arise under international human rights law. Many provisions in international conventions quoted in the Charter are obligations that governments have entered into voluntarily and to which they can be held accountable. The order in which the rights appear within the Charter reflects their relevance towards the IPPF's mission. No order of magnitude or significance among the various rights is implied. The rights included within the Charter include the right to life, the right to liberty and security of person, the right to equality, and the right to be free from all forms of discrimination, the right to privacy, the right to freedom of thought, and the right to information and education. Further, they include the right to choose whether or not to marry and to found and plan a family. They also include the right to decide whether or when to have children, and that healthcare and health protection must be available. This should include benefits from scientific developments. The right to be free from torture and other forms of ill treatment is also included. As one can infer from this Charter, the rights to access a safe abortion fulfills many criteria integral to the fulfillment of women's human rights. Laws that criminalize abortion services affect women only and hence are discriminatory. Forcing a woman to undergo an unsafe abortion violates her right to life, her right to healthcare, and her right to be protected. In situations where contraception is unavailable or information is also not available, and occasionally when contraception fails, a woman must have the right to find a safe service to terminate that unwanted pregnancy, since the failure to do so would violate her right to decide whether and when to have children. The need to seek out unsafe and stigmatized services would violate her right to be free from torture, ill treatment, and a violation of her dignity. Recognizing criminalization of abortion as a violation of human rights of women has taken decades. During the 66th General Assembly meeting of the United Nations in 2011, Anand Grover, the Special Rapporteur on the right of everyone to the enjoyment of the highest attainable standard of both physical and mental health care, clearly said that criminal laws penalizing and restricting abortion provide examples of state interference with women's right to health. He also added that such laws restrict women's control over their own bodies, undermine their dignity, and infringe upon their autonomy. He also stated that criminal laws were ineffective in discouraging women from seeking terminations of pregnancy, and ultimately the only impact was actually determining whether or not abortion was safe or unsafe, as women with unplanned pregnancies are likely to seek the procedure regardless of their legal status. In 2016, the UN Committee for Economic, Social and Cultural Rights also released a groundbreaking general comment. General Comment 22 stated that The right to sexual and reproductive health is indivisible from and interdependent with other human rights. It is intimately linked to the physical and mental integrity of individuals and their bodily autonomy. This is linked to rights such as the right to life, liberty and security of person, freedom from torture and other cruel, inhumane, or degrading treatment, privacy, and respect for family life. It is also linked to non-discrimination and equality. For example, the denial of abortion can often lead to maternal mortality and morbidity, which in turn constitutes a violation of the right to life or security of women. In certain circumstances, it can also amount to torture or cruel, inhumane, and degrading treatment. The general comment further added that for states to effectively reduce maternal mortality, they need to provide access to safe, legal abortion and to decriminalize and liberalize abortion practices. It placed a responsibility upon states that to prevent unintended pregnancies, unsafe abortions, states must adopt a legal policy and measures to guarantee all individuals access to affordable, safe, and effective contraceptives and comprehensive sexual education, including for adolescents. These services should guarantee women and girls access to safe abortion services and quality post-abortion care. In India, the Medical Termination of Pregnancy Act of 1971 gives the legal framework within which safe abortion services can be sought and provided. In the last few years, there have been attempts to amend the Act to become more inclusive and make it easier for women to access safe services. Countries such as Nepal and South Africa, which have implemented abortion laws recently, have liberal provisions which allow women to seek a safe abortion in any public health facility without having to offer any explanation. This applies for pregnancies up to 12 weeks. In both these countries, trained mid-level providers and nurses are also allowed to provide safe abortion services, and this facilitates access for women, particularly those living in rural areas where access to a doctor is not easy. India has other laws which, although unrelated to abortion, have an impact on the way services are offered. The PC-PNDTA Act, which was passed to prevent sex determination, is being implemented in a way that is harassing doctors who are providing abortion services, and thus reducing access to abortion on the ground. Other laws which can make access difficult are the POCSO, wherein a doctor is liable to report to the police any case of sexual intercourse of a young woman below the age of 18 years. This makes it difficult for women under the age of 18 to access abortion services. The Prohibition of Child Marriage Act 2006 contains laws addressing marital rape. Here, the age of eligibility for women to marry is 18 and 21 for men. Other laws, however, recognize that intercourse with your spouse is legal if your wife is over the age of 16. This lack of consistency between laws and regarding the age of consent creates an obstacle for young women to seek and receive terminations of pregnancy for fear that their husband may be punished or that the police may get involved. Internationally, some cases have been heard by international committees such as the UN and regional courts. In the Inter-American Commission, denial to safe abortion was recognized by the court as a violation of human rights. In October 2005, the Human Rights Committee handed down a landmark judgment in KL versus Peru. The decision held that the Peruvian government was accountable for failing to ensure access to abortion services to an individual. In 2016, the Human Rights Committee also stated the island had subjected the author of a complaint to conditions of intense physical and mental suffering. This is because the state did not provide her with an abortion service and aftercare when her wanted pregnancy was not viable. This left her in a highly vulnerable position. The committee also found that the state had unreasonably and arbitrarily violated her right to privacy and personal decision-making, which was against her personal interest and her human rights. In the 1988 ruling of the Supreme Court of Canada in R versus Morgentaler, the court ruled that Section 251 clearly interfered with a woman's bodily integrity in both a physical and emotional sense, forcing a woman, by threat of criminal sanction, to carry her fetus to term unless she met certain criteria unrelated to her own priorities and aspirations was a profound interference with a woman's body and thus a violation of security of person. Section 251 was required by the Charter to comport with the principles of fundamental justice. Lower courts had also found that the restrictive abortion provisions in the Criminal Code of Canada were lawful, but the Supreme Court found them to violate women's rights declared in the Canadian Charter of Rights and Freedoms. The Chief Justice of Canada ruled that the then Criminal Code violated women's rights because forcing a woman to carry a fetus to term because of the fear of criminal punishment or because of the unavailability of abortion services may violate potential national laws, failing to recognize the woman's own priorities and aspirations, thereby reducing her status as a full human with rights to life, dignity, freedom from interference by the state and others, and was a profound interference with a woman's body and thus a violation of security of person. The court recognized a legitimate state interest in the unborn life, but considered offensive state-enforced continuation of pregnancy over a pregnant woman's wishes. In contributing to the development of a human rights framework for women's rights, the Centre for Reproductive Rights has put together a document of statements made by different human rights committees. All of these statements were made between January 1993 and June 2008. The CEDAW committee is quoted as saying that it is discriminatory for a state party to refuse to provide legally for the performance of certain reproductive health services for women. The Committee on the Rights of the Child said on several occasions that the committee has made the link between maternal mortality and the high rates of illegal, clandestine, and unsafe abortions. The Economic, Social and Cultural Rights Committee also stated that it requires at a minimum the removal of legal and other obstacles that prevent men and women from accessing and benefiting from healthcare on a basis of equality. This includes, inter alia, the removal of legal restrictions on reproductive health provisions. The Human Rights Committee, which oversees the International Covenant for Civil and Political Rights, also made a statement that the right to life must be interpreted to mean that information on any measures taken by the state to help women prevent unwanted pregnancies and to assure that they do not have to undergo life-threatening clandestine abortions must be committed to. The recent case where Savita Halpanavar died in Ireland due to being denied a uterine evacuation despite increasing septicemia also provoked strong responses from women's rights activists within Ireland as well as globally. The issue being debated is the obligation of an institution to provide medical care by employing adequate staff to deliver and implement it, whilst respecting the rights of individuals. When comparing the competing right to life of the fetus and of the woman, international human rights treaties and authoritative interpretations of these treaties suggest that the right to life, as recognized within human rights instruments, is not intended to apply from the moment of conception. International legal experts assert that the historical understanding is that the right to life, as protected by the International Bill of Rights, begins when a human being is born. This interpretation is supported by the negotiation history of international human rights treaties, as seen in regional and international judgments. Despite this, there are many movements across the world to limit access to abortion. In the USA, for example, organizations that lobby for conscientious objection for medical practitioners If a state fails to provide an accessible alternative, this should be read as a failure to fulfill women's human rights to exercise choice and agency over their own bodies and lives. It also violates their right to life with dignity, their right to health, and also to be free from degrading treatment. Even though several laws have been put in place, both domestically and internationally, to facilitate safe abortions, there is enough evidence to suggest that this is clearly not sufficient and is not being implemented uniformly. Millions of women die every year in India because of accessing an informal abortion procedure. The government needs to initiate several awareness campaigns where women are made aware of when terminations can take place. Information on the legal status of abortion also needs to be more widely accessible, and signposting to safe abortion clinics needs to be widely implemented. Awareness is also needed among healthcare providers, doctors, and law enforcers so they know when terminations can be legally conducted. Government health services are recognised under the Medical Termination of Pregnancy Act, but such services are often inaccessible, unaffordable, and often do not maintain the confidentiality of women who seek their services. The state needs to be held accountable for ensuring that safe abortion services, including the medical abortion pill, are made available to women through the public health sector. Social issues which act as barriers to obtaining a safe abortion, such as poverty, a lack of knowledge, all need to be addressed in order to ensure that women are able to access and fulfill their human rights to the highest available standard of reproductive health rights.